Got to share what your wishes are. If it is your wish to be buried or cremated, returned to the country, or your ashes scattered on the streets of Paris, let people know, and then let them know who you want to be in charge. That ends a lot of confusion, because even when someone passes away, it can create a family dynamic where there's mistrust. Especially with the end of life caretakers.
So, not many people have an opportunity to talk directly to not just any judge, but I'm talking about like a probate estate judge. But guess what? We do. We have that level of access. And I'm so honored and so excited on this episode of the Thank Me Later show with me, your host, Jini Thornton, where we help you master your money and transform your life. We are talking directly to the source, Judge Kenya Johnson. Welcome, Judge Johnson.
Thank you so much for having me. And we're just glad to be able to have this partnership and these conversations, which are so important to our communities.
Definitely needed. So I'd like to take a minute and just brag about you a little bit before we jump into our conversation, because I know when people hear probate estate, they're like, what in the world does it mean? A lot of people don't understand what it means, or other people who knows what it means. It feels a little heavy, feels like a topic that people are trying to avoid, but you can't get around coming through probate court or estate court with you.
Absolutely. Everyone has a family member that is going to pass away, or a family member that is going to experience dementia or some sort of incapacity. And so probate court is really every person's court, regardless of age, financial status, sex, it applies to every single person. And so chances are at some point in your life, you're going to come through probate court, and we're here to help better empower people through that process.
So let me tell you who is with us today. So Judge Kenya M. Johnson currently serves as the elected chief judge of the probate court of Fulton County. As the chief probate judge in Georgia's largest county, I'd like to add, Judge Johnson's mission is to educate communities about estate planning and generational wealth, and to make probate services more accessible to communities in need. And so I know firsthand that that's true, because we have now, I think this is our third year?
Yes.
Third year of working together, partnering together on Black Women Will. And
well, you do most of the work.
Well, thank you for that. But one thing that I can say is you really answered the call. And you not only gave us the support that we needed, but you made sure the people that are around you, the lawyers and everybody, got engaged and involved. And because a partnership is the reason why we've done so well so quickly. So I'm very grateful to Fulton County Probate Court and your support in making us an amazing event, for sure.
Our pleasure. And you mentioned that a lot of people don't know about probate court. Well, when I ran for office in 2020 and I spoke about probate court, people would say, is that where you pay your probation dues? And I knew then that community education was going to be a big part of what we do. And so not only do we want to educate, but we want to encourage people to engage in estate planning, and through the partnership with Thank Me Later, we're actually able to offer those estate planning documents to people. So you helped us put the action behind the mission, and we appreciate that.
Well, I think we have one thing in common, is that we want people to have the real transformation. We're not just trying to give people the information. We need people to take the action, take the steps that they need to. So again, grateful for your partnership and all the work that you do. One of my mother's favorite quotes was "put up or shut up," and you put up for sure. So I thank you for that. So I want to start talking about it. So let me tell you why I'm so into this topic. So 2 things happened to me. When I was 12, I don't know if I told you this, my grandfather died, and my mother took me to the reading of his will at 12. So of course I was the only child in the room. And at 12, I was like, this is interesting. I could not believe what was going on.
Wow.
Now, my grandfather was not wealthy, but he had done well for a man who had never graduated from high school. And he had more than I could tell that his children knew. And even my step-grandmother didn't know. I could see all the shock and the amazement in the room. So that forever had an impression on me. I was like, this is interesting. But at 12, I saw this. Then when I was 29, my mother passed away and I was in charge. And every single thing was in order, Dr. Johnson. Everything, Judge Johnson, was in order. So I'm like, this must be how it's supposed to be. Then I realized that it wasn't. And that's how Black Women Will started, and me reaching out to you. And I know essentially that's what your goal is too. We have to normalize this because everyone at some point is going to pass away.
What a wonderful story. I'm so impressed that your grandfather had the afterthought to prepare in that way. My father was an insurance agent, and so he sold life insurance along with other products. And so every time they would go on a trip, my mother and I, he would call me in the room and say, and show me all of the accounts, all of the assets, where to go if something happened. And at this time, I'm 8 years old, and I'm like, Dad, I'm not going to the bank with letters testamentary to try to handle any business. But he impressed upon me how important it was to plan and to have the conversations about it with your family. So if something had happened to them on any of those trips, I knew exactly where to direct my caretaker to get to the business.
Right. And I know you did have another family situation. Wasn't your grandmother's house? Something happened?
That's true. So whereas my father was the planner, my mother's family was more in line with the average American family, which does not have an estate plan. Less than 50% of Americans engage in estate planning. And so my great-grandparents' house that they walked 2 blocks every month to pay the mortgage and paid off in 30 years, they passed away. Their children passed away. And then it comes to my mother's generation. She passes away without a will. It comes to my generation. And now the property is broken amongst 16 cousins all across the country who barely know each other, much less trust each other.
Right.
So when it comes time to pay the taxes and handle the business, we were not equipped to do so. And we lacked the family foundation to even find out to how to make it happen. And we lost that house that they paid for 30 years. And most people don't know that after 2 years of unpaid taxes, a savvy investor can come and buy your tax lien. And so we are losing property at an alarming rate due to not knowing about probate and lack of planning.
And when you talk about that family situation, 16 cousins, that's a lot. How often do you see situations like that in court?
More often than you think. And it may not be 16 cousins,
Sure.
But what happens is that because there was no estate planning from previous years, and then sometimes people pass away and their family members will live in the house and not do anything with it. And so that's dead equity. You can't get a home improvement loan. You have difficulty paying taxes. You can't sell it. And so it really pays to empower people to handle the business, because doing nothing is going against your interests.
Absolutely. So for people who have no idea what it means to go to probate court, what does that mean? What do you all do? People come to probate court for what?
Sure. So probate court is a court-ordered process that handles the administration of an estate. That is the gathering of assets, the paying out of debts, and then the distribution to all the heirs. So you can either have a will or you can pass away without a will. And then Georgia law dictates how your heirs will receive your items. So it doesn't mean because you pass away without a will that everything goes to the state. That's the big misconception. But what it does mean is that Georgia law favors blood relatives. And so if there's someone in your life that is not related to you by blood or marriage that you want to provide for, a will or an estate planning, some planning is going to be required in order to cover them. Otherwise, your items are going to go to your closest relatives.
So people come to you because someone that they care about has passed away. Now it's time to wrap up all their affairs, bank accounts, real estate, whatever they own, pay the debts or whatever they own. Someone has to be in charge of all that. But what else do you all handle?
Well, so probate court handles guardianships. We do marriage licenses and gun licenses. But as it relates to the probate process, the whole goal of the process, is to notify every family member that an estate has been opened. It's all about notice to the important people, and it's all about accountability, having their information, and so you can report report to them yearly what's happening with the estate and the distributions that were made. And so when you come into probate, you fill out a petition to open an estate. And you'll have to list all of the heirs or all of the people that were listed in a will, if it was in the will.
So you mean these are the heirs? These are people who are related to the person who passed away.
Correct. So
who may be entitled to receive something based on the law of, if, for example, we're in Georgia, but if people are in Maryland or wherever else listening, it's going to follow the rules of that particular state.
Correct. So these are the closest relatives that are due to inherit from someone that passes away. They're called heirs. And if you have a will and you name someone in a will, that's called a beneficiary. So the key is to notify all the beneficiaries, if there are any, and all the heirs. And so once you go through that process and there are no objections, then everyone will walk away with what's called letters of administration or letters testamentary. They're the same thing. It's called letters, but it's actually one sheet of paper. And when you get that sheet of paper from probate court, that allows you to then go to the bank, call the mortgage company, and begin to handle the business of the estate, set up an estate account, and so forth. So once we've gotten all the notice taken care of, then we can begin the process. However, there is an opportunity for heirs to object. They may not want a certain cousin to be the administrator or a certain family member. And that's when it becomes a contested estate, and that's when it's left for the judge to decide who the appropriate manager of the estate will be.
And so I think, Judge Johnson, a lot of people don't understand when someone passes away, they had money in the bank, they had a retirement account, they had a house. If they don't have a will and no one's name is on any of the accounts, that people, you don't have the right to access any of that until you get these letters, correct?
Absolutely. And even so until you get the letters of administration, that's what banks require. And speaking about bank accounts, if you have a beneficiary listed, then the asset is going to go directly to that beneficiary.
And I want to talk to you about that more.
Anywhere, like life insurance, retirement account, bank account, anywhere a beneficiary is listed, that doesn't even go through probate. It goes directly to that person as soon as they present a death certificate. But if there's not a beneficiary listed, then it goes into the estate. That's the pot of assets that a person owned, and that is to be distributed. Now, it has to be distributed amongst the heirs, but the administrator is a very powerful person because they make the decision on whether, if everyone is due $100,000 and there's cash and there's a house worth $100,000, then the administrator has the choice of saying, I'm going to pay you out in real estate or I'm going to pay you out in cash, but you'll get your $100,000 worth, but it's still the administrator's decision and right to pick how they distribute the estate.
And I want to just go off of the comment that you just made, because I was going to talk to you about that later. When you talked about we can bypass some of this, because I know it sounds complicated, and it can be complicated if people don't have all their stuff together. People don't even know all the bank accounts people have, can't find the life insurance, just the amount of time people spend looking for stuff. But when you talked about having a bank account, and you can have a beneficiary on a bank account or on a retirement account, can we talk about that a little bit?
Sure.
Because I'm thinking not only is it better that you can bypass probate, meaning you don't have to go to court to have access, but once you present the death certificate, now you have access and you can keep things going, and now you don't have this money frozen. So how do you do that? If you want to add that payable on death designation or that beneficiary, what do people need to do?
And so when you open a bank account, that's usually the opportunity to put the beneficiary on there, but it's always important to check in every so often to see if that is still your wishes, because, you know, the bank accounts that I've had over 20 years. And so my children weren't even in my life then. So I may have put someone on there, and maybe now it's time to take a look and see if that is still my wishes. Do I want to have to go to someone else? You may have had a loss, a marriage, all sorts of life events happen. And so usually at the point of initiating a bank account,
right,
or that retirement account, you can do that. But at any point in time, you can go in and change your beneficiaries. And you're recommended to review that every so often.
And let me just say this. I'm going to look directly in the camera when I say this to people. Please follow Judge Johnson's advice and check your beneficiaries at least annually. You know, I know you see it too, where they have someone listed that's already passed away. People have gotten divorced or remarried.
Oh, the
They still got
ex-wife is a big one.
Listen, the ex-wife is still on.
Yes.
She happy now.
And the new wife is not happy.
But it happens all the time.
It does.
I recently had this situation. I had a college classmate whose husband had passed away. His first wife had been dead over 10 years. Her name was still on everything.
Ugh.
So not only was the ex-wife or the previous wife on there, she's dead.
Yeah.
So guess what? Everything was going to her beneficiaries and not to the new wife. So I'm just like, it doesn't have to be this complicated. All we have to do is take, half an hour, a couple of times a year, once a year, to please check in for your life insurance, your bank accounts, your retirement accounts. Please take the time to do this, people.
And the flip side of that coin is when you have someone on the listed as a beneficiary, and again, things have changed. You life events have happened. Someone has passed away. Relationships change, and again, or when a life partner, say if you've been in a long-term relationship, but if you didn't specifically provide for them, or we also see end-of-life caretakers may have been promised things at the bedside, but if you don't put it in writing, those people, who, if they're not your blood relatives, they may not be accounted for. And also, having a will is a wonderful opportunity to think about philanthropic giving. We are all involved in something, be it an organization, a church, an alumni association, a fraternity, whatever it is that you love. When you're no longer around, they no longer get your dues, your tithes, your support. And so we also encourage people to think about supporting those causes that you love so much when you're no longer here, because they were causes that you love.
So let's talk about a couple of myths. I like to debunk a couple of myths. So I know people say, I just wrote it down. Judge Johnson, I wrote down, I just wrote it down on a piece of paper on the back of a napkin, or I told them. They know what I want. They know what I want. What does that carry any validity? That's not a legal document, is it?
Absolutely not.
Do you see that a lot, though?
Well, so I'll recall a very well-known case for you, and that was Aretha Franklin. She had about 3 different versions of a will that she was jotting down on a notepad, and they found the latest version between the seat cushions of the couch that she favored. And so the thing about Georgia law is a will requires the signature of 2 disinterested parties. So it can't be anyone that you're giving anything to. And so you have to have that safeguard in place so that someone doesn't say, well, I found her will, it wasn't signed, but it gave everything to me. So it provides that security, but in order to be a valid last will, it must be signed by 2 people. Otherwise, it is simply not a legal document. It has no bearing on what the court considers, and will very likely be considered an intestate estate.
Now, here's something I also hear a lot, and you probably hear it too. I don't have any children, so I don't need a will. That doesn't pertain to me. True or false?
That is very false, because if you pass away and you don't have any children or a spouse, let's just assume you don't have children or a spouse, then it's going to go to your parents or your brothers and sisters or nieces and nephews, depending upon who's closest to you that still remains here on earth. And so you've developed relationships in your life, you've loved and lived. And so if you want to provide for those people, anyone in your life that is not of blood relationship, you need to write it down in an estate plan.
All right, one more. So what about that person who says, I don't have a lot? I guess a lot is relative. I don't have a lot. So this is not important. My family, they can figure this out. And what do you say to that?
You have more than you think you have, and whatever you do have can probably help someone. And so if you feel like you don't have much, or your family wouldn't be interested in what you have, then that's a wonderful opportunity to think about philanthropic giving, because even if it is merely the clothes in your closet, someone could benefit from that. And it's a great chance to plan for how you can leave a legacy in your name.
I love that. So had a couple of questions submitted to us from our Thank Me Later community ask you. So I am going to read a couple of questions from you. So this is from Natalia.
Okay.
And she says, Are there any unique considerations that arise during probate when the deceased has remarried and has both biological children and stepchildren?
All right. Well, that is a great question. Thanks to Leah. Well, stepchildren are not blood relation and they are not considered heirs if there is not a will. So they will take nothing. And it's only the biological blood relationships, either half or whole. Georgia law doesn't make the distinction. Stepchildren will not be covered. Blood children will be covered and accounted for.
I did not know that.
Yes.
And so blended families must be pretty complicated.
They are. However, it's actually pretty simple. If you're not blood, then there's really not much to talk about. Unfortunately, the way it goes is that Georgia law favors blood relationships. And so if there's someone in your life that you want to account for, you got to put it in writing with 2 witnesses.
You're going to have to put that in writing.
Yes.
So, Judge Johnson, what about that situation where you have a couple? They both, were married previously. He had a previous set of children. She had a previous set of children. Now they come together and they have children. So, but they have these assets together now. You know what I mean? But they have these different sets of kids. How does that work in a blended family?
So it really is based on how the property is titled. So if a man comes into a relationship and he has a house in his name, that house is not considered a marital asset of the new family. That is his separate property, and Georgia law recognizes that as his separate property. And so when that father or that the man in the relationship or the one half of the relationship passes away, it goes to his blood relatives and whoever he is currently married to. But the spouse's family members will not be able to take advantage of any sort of asset distribution because they were not related by blood or marriage.
And so, everybody, this is all I have to say. When we hear all these different scenarios, it's just easier if you just take some time and put it in writing.
Absolutely.
Yeah.
Absolutely.
Take some time, make your wishes known. Follow what Judge Johnson says. We are in the state of Georgia, which requires these 2 witnesses, disinterested witnesses, and to be notarized too, correct?
Yes, the self-proving affidavit is to be notarized. So you need to have that notarized as well.
Okay.
Yes.
So you just can't sign it, have a couple people do it and you just kind of set it to the side. Like, you have to follow the rules for this to be valid. But the rules are simple, though. You didn't say 12 things.
The rules are simple, and wills are much more accessible than they were in the past. Before, people would charge a lot of money, and it was something that was considered to be cost prohibitive. But now they have wills programs at Office Depot. You can go online. They have a sort of TurboTax will type model where you answer a few questions and out pops a will. And that is not much different from what attorneys do. They have professional programs. They ask you questions. No one's really writing a will from scratch with the heretofores and the royal thous. But you do want to have it tailored to yourself. And they have wills programs that are state specific that comply with Georgia law. And those are very much reliable and used and can be anywhere between $50 to $150.
Right. So I think I just heard Judge Johnson give y'all a very reasonably priced solution. You have taken cost off the table because I know that tends to be a barrier for people. So you're talking about $50 to $150 investment. Only other thing, Judge Johnson, is now is just time. You got to take the time to do it.
Yes.
And you got to take the time to get the witnesses, get it notarized, and then make sure somebody knows where the document is.
That's correct.
Because I'm sure people spend a lot of time looking for stuff, too.
They sure do, and they're hidden or they're found or they're never found. I knew mom or dad had a will, but we never found it. And so, therefore, that goes intestate. We don't really take the word of others that this is what was in his will. And so you've got to have those conversations. You've got to share what your wishes are. If it is your wish to be buried or cremated, returned to the country, or your ashes scattered on the streets of Paris, let people know. And then let them know who you want to be in charge. That ends a lot of confusion.
Sure.
Because even when someone passes away, it can create a family dynamic where there's mistrust, especially with the end-of-life caretakers. Sometimes they have a closer relationship with the person because they're caring for them. And whereas the family member in another state may say, I should have gotten more of a share in the will, but you influenced her because you were in her ear saying you should give all your assets to me. So there are several reasons, once you have a will in place, that family members can still contest a will. And so by having the conversations with your family members together, maybe before the drinks start flowing after
Right.
Thanksgiving dinner,
Right.
then everyone's on the same page. Everyone heard it out of your mouth, and that ends a lot of the confusion when the time comes.
And while you're talking about that, let's talk about the family where whether it's the children or the grandchildren don't feel comfortable having that conversation, the talk.
Mm-hmm.
What are we doing? Where are the documents? What's the plan? What advice do you have for families?
Well, I first want to acknowledge that talking about death and morbidity can be depressing for some people, and they just simply don't want to do it. Oh, I'm fine. Nothing's going to happen to me. But we've seen, in the celebrity world and on the news every night that young people pass away. And so you just never know when your ticket is going to be pulled, for lack of a better phrase.
Right.
And so with that being said, tomorrow begins today. It's never too early to start an estate plan. In fact, here's a funny story from my youth. My aunt just reminded me and showed me that when I was in 4th grade and she was babysitting me, that I actually wrote out a last will and testament. And I gave all my dolls to my aunt, and she kept it and showed it to me many years later.
Right.
And it just goes to, but I was the daughter of an insurance man.
Right.
And so that's what was on my mind, to make sure that my items were covered and I had no more than a few dolls.
Right.
So if you have more than that, it is still very important for you to account for what you have and talk to your family about that. And pick the right time. Again, perhaps pick the right time to talk about money, and also to explain why it's important to talk about it now. I've received a diagnosis. I am concerned about this, or I want to protect the house from Medicaid and from medical bills. What do you all want to do with the house? I want you all to keep it. I want you to sell it. You have to make your wishes known. You worked hard for these items.
Absolutely.
And what you have can really improve someone else's life. The equity in a house can be used to fund a business, send someone to college,
Education.
even bond someone out of jail.
Right.
So having property is very important. And we're living in a society now where young people are being less tied to real estate. They sometimes don't see the value in it. But I'll tell you that owning real estate is the cornerstone of wealth in our society. That's where you get most of your wealth from. And so if you choose to have property, the value is in keeping it, or at least controlling it, so that if you want to sell it, you can sell it, and it's not caught up in a tangled title situation like my family.
Right. But I think you're bringing up a point, though. It's just about having a plan, having a conversation, and it's never too early.
Yes.
Okay? Y'all have to remember that it's never too early, for sure. Judge Johnson, it's really important that people be able to have access to information. So if people want to learn more about those of us who live in Georgia, who want to learn more about Fulton County Probate Court, how are they able to do that? Where can they go?
So I certainly encourage you to visit our website, which is fultonprobategA.org. And most of the common forms for probate are listed on there, as well as some useful information. And I want to let everyone know that if you do have the occasion to come through probate court, you at least, the forms are designed to be user-friendly. Most people that come through probate court are self-represented. They're pro se. And so you can look at these forms, fill in the blank, and really represent yourself. And if you have a more complicated or contested estate, you can get an attorney. But I want everyone to know that they themselves are empowered to handle the business of any estate, and that Georgia law is working to make it as easy and as simple as possible for the end users.
Any other, is there any social media? I see you all posting on Fulton County Probate Court social media.
Yes, and so we are. You can find us on all of our Fulton Probate is on all of our social media handles. So we invite you to tap in and log in and see some of the things that we're doing. We're in the community. We're in senior centers. We're speaking to homeowners associations, and so this is something that we do. And we invite you to follow us and learn more about our journey as we educate more and more people about estate planning.
Well, I appreciate all the work that you do, that Fulton County does. Thank you for your partnership with the Black Women Will. It means so much. And thank you for being on this episode of the Thank Me Later show with me, your host, Jini Thornton. And I can't wait to see the work that we're going to continue to do in years to come.
Thank you again so much. I want to thank you now and thank you later. So we appreciate the partnership and I look forward to working with you more.
Thank you. Thank you, Judge Johnson.